Ladies and gentlemen, dear colleagues, I very happily welcome you on behalf of the Special Interest Group Insurance Law within the European Law Institute to ATILA number 7, the Transatlantic Lecture on Insurance Law, or more specifically for today, on insurance in times of war, particularly focusing on war and cyber exclusions. The organizers of this event are very happy to be yet again able to present you outstanding speakers of this evening, which will be next to the co-organizers Jeff Stempel and Eric Knudsen, Laurelie Masters on the one hand, and Celso de Acevedo on the other hand. At this point already, thank you very much to all four of you speakers for taking this task. Let me also, before we go into medias res, give an announcement. The organizers of this ATILA lecture series have decided to change the rhythm of the events. So far, as you know, we had one topic covered by 2 lectures, filling 1 semester of time. Now we realize that the pandemic fortunately allows again for more in-person events and also for more in-person projects that the European Law Institute's Special Interest Group on Insurance Law could pursue. And besides, we observe that lots of other exciting events are being offered online. They may not be as exciting as the ATILA lectures, but they are still very interesting and you may want to attend them as well. And so we thought that it was appropriate and probably also in your interest to present less lectures simply by following the rule that sometimes less is more. So we decided to reduce the number of events. We will cover 1 topic by 1 lecture, and that means that the lecture that was announced for the 10th of November will actually be cancelled. And instead, we will turn back to you and announce a new topic and a new date for spring 2023. And we will be very glad to have you all with us again then. That's the announcement. Let's go in medias res. And I'm very happy being allowed now to present the speakers of the first lecture. They do not need to be presented. They are very well known in this circle. It is Professor Jeffrey Stempel on the one hand, who is professor at the University of Nevada, Las Vegas, and Professor Eric Knudsen on the other hand, who is a professor of Queen's University, Kingston, Ontario. And they will talk about the topic, the combative war exclusion, a short history, overview, and even a look to the future. Thanks very much for this, Jeff and Eric, and the floor is all yours.
Thank you, Helmut. Hopefully everybody can see the screen. Our format, for efficiency's sake, Eric will largely indulge me, except for the occasional comment if I err in this, and then we'll have some comments at the end. And so what I want to just remind everybody, of course, is why do we have a war exclusion? And of course, we have the basic concepts of insurance about trying to pool the risk, but to have that risk be uncorrelated, to have it be random, to have it be fortuitous, to have it be relatively predictable with the law of large numbers as well. And of course, during all that time, it's good to be in the insurance business, banking premiums, invest in them, and so on. And of course, what you don't want is to have the event where a lot of correlated risk is hit at one time, or we have to pay in clumps, or where you have it, what Eric likes to call a clash event of something that is really out of the ordinary. Now, unfortunately, hurricanes are not necessarily out of the ordinary, but really bad ones like Ian create problems for insurance. War would create even more problems because of its widespreadness, because of the correlation of the risk, the way that it deviates from the norms and the predictability. It can be acute, it could be at various levels, as we've seen, and it can run on levels of sort of almost a civil war to sort of a theater war to something more global. And then the losses occur quickly, and there is immediate demand, which fuels additional disputing costs, which is going to undermine the investment operations and just make it very difficult. So we're used to a war exclusion because it's what we like to call a mega risk, right? It's just very disruptive and is not the sort of thing, at least at ordinary premiums, that carriers want to carry. And I think we would put in flood, earthquake, nuclear disaster, pandemics in these sorts of things as well, notwithstanding whatever debate there is about COVID coverage, depending on your policy and which country you're in. But certainly things like flood, earthquake have tended to need some sort of government backing in order to get it underwritten in any significant way. But it to some extent wasn't always this way. Many of you are familiar with a famous case called Carter versus Baum, which is the birth of the utmost good faith doctrine in disclosure and applying for insurance. And that's what it's remembered for. It's a famous Lord Mansfield opinion, but it actually related to what we might call a war, or at least a mini war, or something that would give a court pause today about whether the war exclusion applies, which involved the seizure of a fort in the privateering days in which the great powers were struggling for influence in different parts of the world, in this particular case in Asia. And so we forget that part of the case and that part of the maritime industry, when to be insuring a voyage was to some extent insuring it against privateering or being caught in the jaws of war as well. And so there was actually more coverage there in the sense of the concept of coverage. And when you saw cases about privateering and who had the rights to the goods, they were often fought on insurable interest grounds, as in the famous case of Lucina versus Crawford. So they were not always among us, and they weren't really part of the Lloyd's culture. We might say that war risks were almost considered an ordinary risk once upon a time, because to be at sea was to be at risk of being affected at least by pirates, if not by forces of a sovereign nation that might get in the way of the sea lane, or might seize cargo, or might sink a ship just because it was flying under the wrong flag. And so there was a tendency in that part of the early days to actually cover these things. There was even specific war risk coverage that was offered in the 18th century as well. Lloyd's had a policy that enumerated perils, and many of them did touch on exactly these sort of things. But we start to see a war exclusion more in the mid-19th century. And one theory of that is that to some extent things had simmered down, and war to some extent, or at least seizure of ships by force, became less ordinary. The pirates were crushed. The great powers seemed to be in rapprochement about how often they would attack each other's ships and things like that. And so at that point, normal changed, and normal required a somewhat different sort of approach to risk. And at least for regular premium rates, insurers were not nearly as excited about having war-related losses, so they began to exclude it in some form. And the first wave of the exclusion arrived, as I said, in the late 19th, early 20th century, maybe even mid-20th century. In the 20th century, things like the Spanish Civil War, where there were a lot of civilian casualties, began to accelerate the drive to exclude war, or war and its cousins like civil insurrection, civil commotion as well. And right from the start, and this is something that our other speakers will comment on, particularly Laurie Masters on some of the US litigation, war exclusions have always been construed narrowly. And one of I think, classically illustrative cases is one from the mid-19th century involving a US Civil War related loss, but not enough to trigger the war exclusion. Confederate forces had extinguished the lighthouse at Cape Hatteras, North Carolina. Because there was no lighthouse, a ship ran aground. The question was, because the lighthouse had been disabled as part of the war effort, did that mean that the war exclusion applied? And the court said no. And for many of you, this will be a familiar doctrine, the idea of causation in insurance. You're normally looking at the cause closest to the loss or the dominant cause of the loss. And so even if war is in the background, even if war is somewhere in the chain of causation, if it isn't the immediate cause of loss, courts, at least in the United States, and I think generally throughout the UK and other countries as well, tended to give the war exclusion that narrow exclusion. And of course, remember, it is an exclusion. So under the rules of the game of contract interpretation, it's usually construed narrowly, it's construed strictly, and the burden of persuasion to show its applicability is generally placed on the insurer. Along with that, and the fact that ambiguous language tends to be construed against the drafter, which is the insurer, the war exclusion had an uphill fight. And certainly if there were any fact disputes, it became difficult to see it applied. So I cite on this slide to the Welt case, in which there was a train robbery where the perpetrators were in uniform, but because it wasn't clear that they were legitimately soldiers, as opposed to simply wearing the uniforms as part of their robbery getup, there was no applicability of the war exclusion as well. And as we'll see, there's been almost as much reluctance, at least in the US courts, to give a real broad construction to the riot or civil commotion exclusions that are often embedded in a war exclusion or come along with a war exclusion in the policy. So we see this tendency continuing, at least in the US in the 20th century. The Queen Insurance versus Rutgers Fire case, you have ships that collide, and they're where they are because they're carrying goods back and forth for military supplies, but they're not actually military ships. So the court says, no, war exclusion doesn't apply. But in another case, again, the life insurance cases can be a little bit inconsistent, but a life insurance case from the mid 20th century, after a soldier falls to his death after the hostilities have ended, he's not barred from coverage. That's not the same as if the soldier had been shot during a war or had died of exposure during the war. So this was how one commentator in a national publication summed it up. War exclusion, as you might remember, was discussed quite a lot in the week of the September 11th attacks in the US. Courts will relegate the war exclusion to a non-performing role if it can be shown that the damage to covered property can otherwise be attributed to some specified cause of loss. That's perhaps a little strong, but it's not a bad peroration of exactly what seems to be going on as long. And lest I give you the wrong impression, this doesn't mean the war exclusion is completely ineffective. Sometimes war is war, and you see cases where it's pretty directly a result of hostilities, or it's committed by sovereign troops in some way as well. So we see a series of cases here. Obviously, the tragic life insurance cases, if a soldier dies on the field of battle, that's excluded. That's why in the United States we have a government program to provide life insurance, again with fairly low policy limits, but life insurance for soldiers, because they won't get life insurance ordinarily under private policies because of the war exclusion. If you have seizure of ships that by hostile forces, that will typically be part of the war exclusion as well. Ironically, and I don't have them up here to list, but the Spanish flu pandemic of when Americans called it the Spanish flu out of an unwillingness to admit the US military's role in fostering it by putting 6 soldiers together in a barracks. But that was the 1918 pandemic, the greatest one prior to COVID. And the cases went a little bit both ways on that, about whether or not that type of a loss was considered enough of a resulting from war or not, when it afflicted soldiers who were on duty, but not in the theater of war. You do get what I would call a functional approach rather than a literal approach or a broad approach. Again, that's consistent with the idea these are exclusions. So in one case, for example, a soldier's death on a reconnaissance patrol was covered, even though that sort of looks like a classic military activity, but the ceasefire was supposed to be effect. in effect, or was not covered. Even the ceasefire was not in effect, but it was still obviously a death from hostilities. And the same with the idea that if a war is not declared, it might not apply to the war exclusion. That argument has never done very well for policyholders as well. I did mention that sometimes war comes interwoven with an insurrection, a riot, or civil disobedience exclusion. And when these are sufficiently widespread, they are treated a lot like the war exclusion. They're narrowly construed, but that doesn't mean that they're not applicable in some sort of form. And so, as you can see from these cases that are listed here, even if there hasn't been a formal war, when there's been fighting in the streets, so to speak, that causes the loss, that tends to be something that would be excluded from coverage. But something like vandalism by school juvenile delinquents is not the same thing as people in the streets with guns on the streets of Panama City or something like that. So the courts have tended to draw a perhaps fuzzy line, but still a line that you can draw. And I can't resist, whenever we're talking about riots, talking about the famous Evel Knievel jump, which to Americans of my generation is something that's known. Knievel was a daredevil motorcyclist who some of you might remember was engaged in, jumping things between casinos in Las Vegas, etc. And his great mission was to jump the Snake River Canyon in Idaho. And the crowd control and the planning for the event was not particularly good. The crowd got out of hand and looted some of the vendors. The question was whether or not the riot exclusion applied in that particular instance. And the court said, yes, it did, at least in the lead case, as foremost insurance versus Putsier. But in another case, they cut a break on property insurance for a vendor based on alleged representations that had been made to him by the agent. So you do get result orientation there like you do anywhere else. But in the modern era, probably the go-to case in the United States, that many of you may be familiar with, is the Pan American versus Aetna case. That was the hijacking of a plane by militants, took the plane away, destroyed it. And this was protracted litigation in the Southern District of New York, Manhattan, went to the Second Circuit Court of Appeals, was heavily litigated by top-notch lawyers. And the court there said, war exclusion doesn't apply to hijacking. And just to put a bug in everybody's ear for the future, one of the driving forces of that decision was that there were available more specific terrorism or hijacking or theft or maliciousness or vandalism exclusions that were not used. And so the court sort of did an expressio unius est exclusio alterius approach. When there were more specific exclusions available and they weren't used, the court was reluctant to expand the war exclusion to hit those. One of my, I wouldn't say favorite cases, but interesting cases that shows how American courts can be quite resistant to applying the war exclusion is the Holiday Inn versus Aetna case. This involved the Holiday Inn in Beirut, which became sort of ground zero for a lot of fighting. One side would take it over, then the other side would take it over, and they'd use it for snipers and they'd use it for billeting troops, etc. Well, the hotel was a wreck by the time the hostilities ended, but the court said it's not really war because these are not sovereign nations in this same way. And so you do have some pretty restrictive, notice these cases are all kind of the 70s, 80s to the early 90s. Late 20th century, the war exclusion looks like its heels in the United States, on its heels. Then come the 9/11 attacks. And they're of sufficient magnitude that, of course, insurers think about invoking the war exclusion, but then they decide not to. And part of that is because it's just such a tragic event that it looks like bad public relations at that point as well. But because of that, and because of some comments early on by major American insurance figures like Warren Buffett that the war exclusion shouldn't apply or that they weren't going to enforce it, the war exclusion never got invoked, which immediately shifted interest, as you know, to having a more specific terrorism exclusion in the policies, and also was an impetus for the Terrorism Risk Insurance Act to try to provide some ability to continue to sell that sort of coverage, even though it became, needless to say, a very hard market in the wake of something of the magnitude of the 9/11 attacks. So more recently in the US, before we get to what might be called the cyber battles that our other speakers are going to address, a pretty illustrative case that follows the playbook in the United States courts is Universal Cable versus Atlantic. Some of you may have remembered, I was only able to stay with it for about half an episode. There was a television miniseries called Dig, starring Jason Isaacs, who you might remember as Lucius Malfoy from the Harry Potter movies, as in a mystery in Jerusalem. Well, it had filming problems because of the threats of violence there. And so there were interruptions of coverage there. But the court, pretty much in line with American jurisprudence, said this isn't war. It's just basically being afraid of crime or vandalism or destruction. And so it certainly is not war, because there's not the involvement of a sovereign nation, and there are not hostilities in a field of battle. But it did remand on the question of whether this might be considered insurrection or rebellion. No further word on that case, or no further developments on that case. But that's the state of the law. It, like the cyber cases you're going to hear about, collects a lot of the law on this, which has been fairly consistent in this regard. This slide I won't belabor you with. It gives you a flavor of what the nature of that particular exclusion was and what it involved. I won't say too much more about the Merck case on this necessarily. I'm going to slide by that and slide by the Lloyd's LMA language that we may see more use of as a more targeted way of exclusion. But I again want to raise this issue of what I'll call the Pan Am problem. And insurers have a little bit of a damned if you do, damned if you don't problem in choosing their language when there is an array of different exclusions out there. Do you need to put them all in? Does using one exclusion to instead of another make you vulnerable to the post hoc judgment of a court that you mustn't have intended to cover something because you didn't use this particular exclusion? If the war exclusion in general is going to be ineffective, what's going to replace it? And so one of the questions that Eric may want to chime in on at this point is, what is our future of the war exclusion? And terrorism has been relatively contained the last decade or so, as opposed to the early 21st century. We haven't had things like the train station in Madrid. We haven't had 9/11s as much, but it's still an ever-present risk. Certainly, as we're seeing, cyber seems to be the emerging battlefield. Will there be more riots, particularly as politics in various areas with governments that are more or less authoritarian and where we have protests, will those become the sort of losses that need to be more specifically addressed? And will we see the war exclusion as a war exclusion not be used as much by carriers as a defense against these sort of clash events, or if not clash events, unusually large and abrupt losses that they would prefer not to cover? Eric.
Thanks, Jeff. So I'm going to have a couple of thoughts about the sort of future forward, and thanks, Jeff, for laying the groundwork. This is great. If we take war as what Jeff mentioned was a clash event that cuts across many lines of insurance and hits many policyholders at once, then you get some really interesting parlays into what it really means. And we're going to hear from Lorelei Masters soon about the war exclusion in terms of cyber hacking. And you start asking yourself, what is this three-letter word war actually stretched to mean? So for example, if we're going to use the war exclusion for a cyber hacking problem, we may end up in the same pattern we saw for the things like the absolute pollution exclusion. We saw it with cyber insurance. Now we're seeing it with pandemic-related losses. And that's really a hard market with hard exclusions and a high price. and then followed maybe by courts saying, "Oh, insurers, you went too far, and we've been interpreting this too broadly." And then what do you get? You get a price drop, and then a gradual incorporation of that coverage for what used to be excluded behavior, say excluding cyber hacking for a war reason, into what you'd think would be standard expected lines of coverage. So that's one issue. Maybe we're going to see that same pattern that we've seen in other kinds of insurance. Another one I think is coming down the pipes is, it's a war. Like, really, what is that? The discussion Jeff sort of drew out was the court sort of having to plug into this idea of what is a war. Maybe the definition of war is an issue in this clause. It's particularly in an era where we're past world wars and now into what I think Jeff has called sort of mini wars. We've got problems around the world that are quite acute, but they're localized. So how does an insurer or a policyholder get evidence of what's a war? Is a cyber hack a war? Is it a war if it's state-backed? And if it is a state-backed cyber hack, how do you get evidence of that? And how is that a loss any different than a couple of people in their garage who put out a big, hack to you? So in non-cyber policies, maybe we've got a move of insurers excluding all hacking, warlike hacking entirely, and then selling cyber as an add-on endorsement that doesn't worry about the origin of the hack, but maybe charges you a premium. These are some thoughts about where this is going, but I'm going to be really interesting to see where the other speakers take what is a war and how do you work that in different contexts. Thanks.
Thanks, Eric. And at this point, just to keep us on track, I want to introduce our next speaker. Laurie Masters is one of the preeminent policyholder side lawyers in the United States at the Hunt and Andrews Kurth law firm. We had the pleasure of being part of a group of 40 advisors to the American Law Institute restatement of the law of liability insurance, which many of you know was hotly contested as to certain provisions. The War Exclusion was not one of them. I think we didn't have a single discussion about it, but of course, now it's emerged to the forefront of American issues. With that, Laurie, who's going to talk about the Merck versus Ace case and some other recent litigation developments.
Thank you, Jeff. So I'm just going to warn everybody that Oliver's going to help me with the slides here. Because I didn't have the confidence that I could do this correctly. So I'm going to talk about this intersection between cyber and cyber coverage and war exclusions. Specifically, I was asked to focus on two cases that are pending currently in U.S. courts, and they both arise out of the NotPetya, I guess I will use my terminology, but it's an issue. What was NotPetya? Oliver, if you could advance to the next slide. So NotPetya was, all of us may remember this, but this goes back to 2017. And in June of 2017, there were cyber attacks that involved this NotPetya malware, I should say. And many companies were affected by this. I would say not just in the United States, but elsewhere. We're going to focus on these two litigations involving Merck and Mondelez. But other companies were involved, including Marriott, Roche, Lion Air. One of the cases that Jeff cited, TNT, which is FedEx European subsidiary. You all may be more familiar with that than I. So let's start here with talking about the Merck case, which was filed in New Jersey State Court, the New Jersey Superior Court, which is a trial level court here in the United States. And the NotPetya, I would say, might loosely be considered a Trojan horse type situation. So especially in Mondelez, where this is a big part of the argument, the malware was present on the system, but undetected, at least with some of the companies that were attacked. But then it was activated here with Merck on June 27th, 2017. So it caused widespread damage. 40,000 computers were infected. And it led to a $1.4 billion loss. I thought the zeros there would get everybody's attention. Merck has had, at the time, a large property insurance policy, what we would call all risks policy, with a limit of $1.75 billion. And that was led by a captive insurer, but the litigation involves the reinsurers, which the litigation and the decision by the trial court refer to as insurers. So I'm using that terminology here. So after coverage was denied based on the war exclusion, Merck sued the reinsurers, as I said, in 2018, and they specifically relied on the war or hostile acts exclusion because of the allegations, or it was widely reported in the press, we probably all recall it, that NotPetya was produced by entities that were at least affiliated with the Russian government. And it was specifically, I think we all recall this, targeted, intended ostensibly to be targeted against Ukraine, given the ongoing conflicts there that began, maybe they predated, but certainly with the annexation of Crimea in 2014. And Russia, the Russian government, denied that it had involvement with NotPetya. And so Merck argued that NotPetya was not subject to the war exclusion because it didn't involve state actors, and that they had not met their burden, the insurers, under New Jersey law, and I would say generally accepted principles of policy interpretation in the US, to meet their burden that the exclusion, which needs to be under US law narrowly construed, should apply to preclude coverage under those facts. So Oliver, if you could switch to the next slide. So in a thing that we coverage lawyers love, sorry, Oliver, are you able to advance?
I try, but it doesn't work.
Well, I'll keep talking.
Okay, now, here you go. I'm sorry.
No problem. You know, I think we're actually pretty lucky here with all this geography that we're traversing here. So this is the text of the war exclusion, a war hostile act exclusion that is at issue in this Merck litigation. And of course, coverage lawyers, like all of us, I think on the Zoom, love this stuff. So you can see here, and I think, you know, this resonates then with a lot of things that, at least to me, that Jeff and Eric were talking about, because you can see here in the subparagraph 1A1, it talks about excluding loss or damage caused by hostile or warlike action, interestingly, in time of peace or war, although that hasn't been a big focus of the arguments in Merck. But then it specifically talks about these actions by any government or sovereign power, de jure or de facto, or by military, naval, or air forces, or by an agent of those of such governments or powers. So this one does have, although it's not really an issue in Merck, it does have a concurrent causation exclusion here too at the end. So, you know, lawyers like me representing policyholders, we decided that Jeff should mention that in the intro. I think I can understand and be fair to the arguments on the other side, but I do come from the policyholder side. So it's very clear, it seems to someone like me, that it's difficult under the facts that are alleged in Merck for an insurance company to really make out its burden. So I've read a number of commentaries, more than a number probably, from both US lawyers and also from abroad. I would say that sometimes the commentaries outside of the United States do not quite get, my view, the extent to which contra proferentum and narrowly construing exclusions and putting the burden on insurance companies really should and does hold sway in US courts. And so here in New Jersey, considered a pro-policyholder state, I would say. I've done a fair amount of litigation under New Jersey law, and I'm not certain that that reputation is always as well-deserved as perhaps some of us on the policyholder side think, because I think that the law there in New Jersey, in the context of U.S. Case law on principles of policy interpretation, is fairly even-handed, actually. But in any event, it does clearly put the burden on the insurer to show that that interpretation, the insurer's interpretation, is the only reasonable interpretation given the facts at issue. And as those facts are disputed here, not just between Merck and the insurance companies, but also among the government actors involved, it seems difficult to see how factually the insurers in this case can really meet that burden. So, Oliver, if you advance to the next slide. At the end of 2021, the trial court addressed cross motions for partial summary judgment in the case, and the court held that using terminology used in the decision, traditional war exclusion under this all risks property policy did not bar coverage for this malware attack from the NotPetya virus. And again, in something that we insurance coverage lawyers love, the court focused on dictionary definitions, and well, it focused on dictionary definitions with regard to hostile acts, as you can see in that bullet there, using, if I'm recalling correctly, Merriam-Webster to define hostile characteristic of an enemy. Said that under the facts that wasn't clear here. And then the court also said warlike, we don't need to define that. Warlike means like war. There's only one reasonable meaning there, and it has to involve conflicts between nation states. So this case is interesting in a lot of ways. It's on appeal to the New Jersey Appellate Division, which is the intermediate appellate court in New Jersey. So I assume that it will eventually make its way to the New Jersey Supreme Court. But right now it's pending in the appellate division. And it's a little difficult to get information about this case because it is under seal. And I reached out to the lawyers who are involved in the litigation, and they weren't certain how much they could tell me. So it's a little unclear, but it is definitely on appeal, and I assume that the ruling will be made public once it's entered. But you can see here that commentators have come down on this, I would say on all sides of this issue. But one of the things that they focus on is this issue of what we call silent cyber coverage, meaning is this I would say it is a cyber attack or a ransomware attack. And if that's the case, then that takes it out of the war exclusion. And here, as the trial court said, trial court in finding coverage, in effect, people would say endorse silent cyber coverage in the sense that this is a, in air quotes, traditional property policy, not an explicit cyber policy. And yet the court found coverage here. So, again, hearkening to what Jeff and Eric were talking about, does this mean, and we see in the press, and I know it will be discussed later in the presentation, that insurers are thinking about how to or whether to focus these exclusions more on the actual situation that arises from things like NotPetya. So, Eric, I'm sorry, Oliver, if you could advance to the next slide. The other case that's pending here in the States that's getting a lot of attention on this issue is this Mondelez International versus Zurich litigation. Now, interestingly, this is scheduled, as one of my next slides will say, for trial starting October 11th, after a holiday here. I think we called Indigenous Peoples Day. Now, I'm not certain. It's definitely celebrated. The council told me every year in Chicago, in Illinois, unlike in Washington, D.C. and unclear what they call it. It used to be called after a certain explorer who ostensibly discovered America. So discovered the New World, I guess. So now here, this also involves NotPetya, and this is not pled in the complaint, actually. But talking to counsel yesterday, who's taking this case to trial, they said that there were actually two different attacks or incidences where the NotPetya virus was activated. And the first one on June, I think they found this out later as they did further investigation, and this is how they're going to, I understand, argue this in court, that there was an attack on June 22nd, and that the virus was present, but it was activated in the systems, in other words, for Mondelez, undetected, but it was activated on June 22nd, took down one set of servers. Mondelez is a big international snack food company, Cadbury chocolate, forgetting all the things that they make, but, selling things around the world. So they had one set of servers that was taken down on June 22nd, covering a large portion of their business. And then on June 27th, the second set was incapacitated, which pretty much took down the rest of their computer capabilities. So they were totally shut down for a number of weeks. The overall loss exceeded $100 million because of sublimits in their all-risk property policy. And this is an issue I think that's interesting here. They're seeking $100 million, but this coverage that they're going under is sublimited to 50 million. So there's a number of occurrences issue here. And Mondelez is arguing that the two different incidences, one on the 22nd of June, the other on the 27th, each one constitutes a separate occurrence because of the definition of occurrence there, which is any discrete event. But the other thing that I think is interesting about this case, and certainly counsel for Mondelez has made clear in discussing it, they don't consider this silent cyber because they specifically bought coverage or I guess probably negotiated for language that in their view covers this kind of situation. So you can see it here in the bullet where it says that Zurich's, this is one policy that Zurich issued, and it says that it was to cover physical loss or damage to electronic data, programs, or software, including loss or damage caused by malicious introduction of a machine code or instruction. So from their perspective, this plainly covers what happened here. The other thing that I think is interesting, and this is in the complaint, on June 1, Zurich, so this was in June of 2017. They gave notice almost immediately. June 1, 2018, Zurich denied coverage based on the war or hostile acts exclusion. They later then rescinded the denial and then reasserted it in October. And I think that counsel's perspective here, although not clear to me, is that they may have done that because they realized they wanted to deny coverage on more than one ground, and their initial denial was only a denial under the war exclusion. So if you advance to the next slide, this is the war exclusion in Mondelez, and again, with the backdrop that the insuring agreement language, the coverage grant specifically refers to coverage for electronic data, et cetera. But again, you can see here that this refers to hostile or warlike action by any government or sovereign power, military force, or an agent of any of these parties. So again, under the facts with NotPetya, it's going to be interesting to see how this turns out. So if you'll advance to the next slide. So the status of this is interesting. I think we should all, I certainly plan to be monitoring this to see what happens with this trial that starts just in a couple of weeks. And this will be a jury trial. And this was from a conversation I had last night with counsel. in the case at Jenner Block in Chicago. So the two issues are whether the war exclusion applies based on the facts on the Pecha virus. And then also, as I said, the number of limits that apply. Zurich is arguing that it should be one occurrence, and the policyholder is arguing for two occurrences. So I have Oliver, if you advance to the next slide, I'll finish up here quickly, but I just put in a couple of other exclusions as comparisons. So you can see this is one that I've been familiar with over the years, oftentimes, you know, in other kind of contexts, other kinds of coverage claims. Just skip right by the war exclusion, but you can see that this one really parallels what is in the Mondelez policy. And then Oliver, if you'd advance to the next one, the next slide. I thought I'd put in the war exclusion from Pan Am. This might have been in Jeff's slides. You can see the difference here. Now, this goes back to the early 70s, as we talked about. It does specifically refer to war. It doesn't have, you know, necessarily the subparts, the organization of the other ones, but it has the same language in subpart 1 where it talks about government or government authority or agent or military powers, for example. So, and it has the civil commotion reference also. If you'd advance to the next slide, Oliver. So one thing that we've seen, and I thought it would be interesting to put this up here because this perhaps leads into the next conversation. This isn't the first time that there's been discussion about how war exclusions should be worded and how they applied. So here's one that the Insurance Services Office here in the United States, which comes up with standard form language for U.S. Insurance policies. This, of course, came up in light of the September 11th attacks in late 2001. But you can see in subpart 4 there a reference to terrorism. And I don't have the definition of terrorism here, a mistake perhaps on my part, but it's generally defined similarly to what Jeff's slide referenced when it talked about politically motivated crime. The definitions of terrorism tend to have some reference to political motivation. So that's the background on Mondelez and Merck. I think it's interesting to see how this will proceed, both in terms of just the litigations that are pending. But there's a lot of commentary that is out there on these exclusions. Some that I've seen has talked about looking at this more holistically or looking to other sources for defining what war means as opposed to perhaps a dictionary definition or common sense definition, what the ordinary person on the street would think about what war is. So I saw references in some of the, I have seen over the months, references to, say, referring to public international law, to the UN Charter or UN statements about what war or conflict might be, what hostile actions might be. I would say I'm not certain that would be productive in US courts, but it might be something that outside of the United States might get more traction. I think here we would really, the general case law and supported by the restatement, I would say, of liability insurance, where the principles of policy interpretation really are the same, whether they're, I would say, property insurance or liability insurance. But there, and in the case law generally here, you look at the ordinary common sense or person on the street type, or sometimes depending on the state, I suppose, business person definition of what a term like war might mean. So with that, I'm going to turn it over to the next speaker.
Well, first of all, I have the privilege, I think, to say thank you to everybody. Thank you very much for all the presentations. Thank you, Jeff, in particular for mentioning evil Knievel. I don't think, I think the last time I heard evil Knievel, I was like 6 years old. And one of my friends in school had a plastic evil Knievel. And I remember throwing him through the kitchen. So excellent. Thank you very much. Thank you, Eric, for raising this very simple question: what is war? I think that is the question you were basically raising, and I was wondering whether you think we've answered this question tonight, or whether there still are some doubts, but maybe we'll come back to that. We have maybe about, Helmut, 10 minutes for a brief discussion if you want. So for all our participants, if you want, you may write your question in the chat, and of course the panelists have the opportunity to ask each other whatever question they want to ask. Maybe just, to give you a minute to think about a question. I wanted to add that, of course, there is an ongoing discussion in Germany about the term war. And Germany is, of course, a civil law country. So you might expect some statutory law addressing the question of war exclusion. But there is none. I've tried to find a provision in the German insurance contract code, but there is none. War is mentioned, I was surprised to learn, in the Austrian insurance law code, but still no definition. So I tried to find a definition in the general conditions of insurance. And of course, there are definitions of war, but I wasn't really convinced either. If you look at the general conditions of insurance, they usually include war, meaning invasion, civil war, insurrection, revolution, riot, military or other forms of seizure of power, which strictly speaking is not a definition, but rather an enumeration. I still don't know what war is. I only have a couple of incidents which may amount to war or not. But do you have any questions you would like to ask?
And I see we have some questions in the chat that I know Oliver and Helmut will want to administer, or Christoph will administer. But can I just ask one real quick one, then I'll be quiet for the duration. Lori, as an American lawyer who watches these things, what's your, as we say in Las Vegas, the over-under, your prediction, your bet on what's going to happen to the Merck case and then the Mondelez case, ultimately, when they're appealed?
Well, on Mondelez, it's in front of a jury in Chicago, Cook County. So therefore, might be true most places in a jury in the US, but I would say that has a very good chance. I don't know, high chance, 75% I'll put, if you have to have a percentage of it going, maybe higher. I tend not to estimate higher than 80%, because there's always a chance in litigation that things go south. But, I think that has a very high chance of success, especially in front of a jury. We, on the policyholder side in the US, the battle, in my view, is always get this to a jury, whatever it is, if you can. In the Merck case, I guess I might be a little less optimistic, but I still think that the rules of policy interpretation and the burden of proof, given that this is an exclusion, favor the policyholder. So I would say that there's a good chance of that trial court decision being affirmed on appeal. Is that good enough, Jeff? He warned me he was going to ask me that.
Okay, thank you very much, Lori.
Let me just kind of close with this thought, trying to answer Eric's question about what is war. My concept of it has always been when it really has that large-scale correlated impact that people don't like to insure at anything approaching standard rates. So something like, shamefully, the January 6th insurrection at the U.S. Capitol, not war, maybe civil commotion, but certainly it's confined, however terrible, to a particular geographic area. And I used to think therefore cyber almost never fit war, but something like NotPetya, where it's done on a wide scale of great magnitude, does kind of create that issue. But again, as a risk modeling thing where I'm only pretending to have any idea what's going on, presumably it would be unlikely that even with large-scale coordinated attempts backed by sovereign nations, they're going to penetrate the security of all of your policyholders at once. And maybe it needs to be a little bit more like boiler exclusion insurance, that to get cyber coverage, you have to pass very stringent protocols of protection. And maybe that's a better way of handling it, and just saying we're going to cover it with something that is more like a very narrow exclusion. Or maybe, let me just throw this out, policyholders would blanch, should there be a comparative negligence sort of provision in the policy, or a breach of warranty provision that would put the policyholder at risk if they're not meeting the minimum standards of cybersecurity?
Okay, thank you very much, Jeff. I suppose those were perfect closing words. We've raised the question, what is war, in the beginning. Jeff has answered the question at the end of the lecture. That is just perfect. Thank you very much. Thanks again to all the speakers. And I thought that was an excellent lecture. I found it very, very interesting. And well, I hope you all agree, and well, have a nice evening wherever you are. At least here in Europe, it's about having a nice evening now. We can close down our notebooks and go home now. I guess it's close to 7 o'clock in the afternoon.
Some of us are still just waking up, Christoph.
Yeah, right. So you guys have a great time, and see you at the next lecture. Bye-bye.
Terrific. Thank you, everybody.
Bye-bye.
Appreciate it.